Hi, welcome to our lecture series on the latest edition of our Law and Business Manual. My name is Jonathan Corbett. I'm going to be covering Chapter 1, so turn over to page 1 of Chapter 1. The title is Contractor's License Law. Now, I am a licensed general building contractor, and I've also been a member of the staff that puts together all of the exam prep materials for our contractors programs, including law and business. I can't take full credit. We have a staff that labors away with me to keep up with all the changes in the state exams. And for this course, we're especially grateful to some individuals who gave us some very valuable input. That includes a construction lawyer, a labor lawyer, an accountant, a bookkeeper, and also a contractor with a lot of experience in business management and project management. So we're very thankful to them. This particular edition of the manual is more extensive than the previous edition. We've added a couple of chapters because the contractor state license exam is covering more information, and so we have to cover more information. So it's been a big project, but we've gone through, and we've also had to do a lot of updating. The mechanics lien law was overhauled a few years ago by the legislature. We had to go through every line of the civil code, which is where the mechanics lien law is found, and make sure that we have the updated version in our chapter. So this manual is ready to go. Are you ready to go? I'm ready to go. Let's just jump right into it. Okay, so if you're on page 1, top says Contractor's License Law. And I just wanted to explain that this term, Contractor's License Law, is used by the Contractor State License Board to refer to any California laws or regulations that have to do with the classification, qualification, examination, licensing, and disciplining of contractors. The Business and Professions Code, note that in bold on your page. This is probably the largest collection of laws relating to contractors. Most legal citations you'll see are to the Business and Professions Code, but not all laws are encompassed in the Business and Professions Code. You also have the Civil Code. So when you're talking about home solicitation contracts or the owner's 3-day right to cancel, then you're going to find that information in the Civil Code. You also have the Government Code, you have the Penal Code, and down at the bottom here, I also want to throw in the Contractor State License Board's rules and regulation. The Contractor State License Board is authorized to adopt rules and regulations necessary to carry out the laws passed by the legislature and found in the different legal codes. Now, the regulations cannot expand or restrict the scope of the laws as originally passed. You know, they're designed to implement, carry out the laws. The manual gives you an example of where the Contractor State License Board rules and regulation will specify the classifications. Business Professions Code Section 7058, it reads, provides a general definition of specialty contractor and leaves it to the CSLB to compile a list of specialty contracting classifications. And it also has to define the scope of the work covered by each classification. So an example would be CSLB Rule 832.10, and that defines the Class C10 electrical contractors classification. Okay, please turn to page 2. Contractor State License Board under administration. The agency responsible for administering the contractor's license law is the Contractor State License Board, often abbreviated CSLB. Note that the board has 15 members. 8 are public members or not contractors. They do have 5 active contractors among the members. They have 1 active local building official, and they also have a member of a labor organization that's representing the building trade. So that's the basic composition of the board. Now, if you jump down, you see where it says the highest priority of the CSLB is to protect the public. And that explains the composition of the board. The board isn't 10 licensed contractors and 5 public members. There are only 5 actively licensed contractors. Contractors have to be in the board. They have a right to be in the board because they're part of the industry, and their information that they can offer is important. If you've ever watched a board meeting, you can see that the non-public members will often defer to the active contractors when it comes to talking about the practicality of a rule or regulations that's being proposed. So they play an important function, but they get outvoted if it comes right down to which rule or which regulation is going to be approved. Again, because of the emphasis on protecting the public and passing laws that are beneficial to the consumer. Next paragraph down, the CSLB appoints the registrar of contractors, a person who serves as the executive officer and secretary of the board. So the registrar is like the CEO, chief executive officer of a big corporation. The registrar and the 400 employees that are overseen by the registrar are responsible for running the day-to-day operations of the contractors state license board. The board itself is only required to meet 4 times a year. Now, they sometimes will meet more frequently, but they look to the registrar to make sure that all of the details of enforcing and administering the contractor's license law are taken care of. The registrar is a name you're going to be very familiar with through your construction careers. You've probably already seen the name if you've filed your application for a contractor's license. The fee, if you notice, was payable to the registrar of contractors. Okay, now looking at jurisdiction, bottom of page 2. I'm going to read this, and I'm going to ask you to highlight it or underline it. It's very important. There are certain areas in Chapter 1 that I'm really going to emphasize. Why? Because the state's going to ask you a lot of questions about it. So here is something that you really want to pay careful attention to. Let's read it. Any business or individual who constructs or alters a building, highway, road, parking facility, railroad, excavation, or other structure in California must be licensed by the CSLB before submitting bids or undertaking projects if the total cost, and we're talking labor and materials, is $500 or more. $500 is something you want to remember. Now, if the work is under $500, then it falls under the minor work exemption. We'll be talking about exemptions shortly. But $500 or more, you need a contractor's license. I want you to look at page 3, top of the page. Notice it is a misdemeanor for any person to engage in the business or to act in the capacity of a contractor without first obtaining a contractor's license, unless that person is exempt. So it's a crime to contract without a license. You're not going to just be subject to disciplinary action by the registrar, a fine, a civil fine. You can be prosecuted criminally. Now, the sentences you're likely to get, the fines, the jail time, for example, have to do with whether you have previous convictions. And at the very last sentence in this paragraph, it says the CSOB may also issue a civil citation. Be aware of that. So you could be facing a judge in criminal court, and the registrar could also be assessing a fine. Next sentence, next paragraph. It is a misdemeanor for an unlicensed person to advertise for a construction project who does not hold a contractor's license in the classification covering the project. Okay, that's very important. Those of you, especially who are applying for specialty contractor's license, need to read the scope of the classification very carefully so that you know what you can and cannot do as a specialty contractor. It also says, however, an unlicensed person may advertise for work if the contract price for labor, material, and all other items is less than $500. That's the minor work exemption. And, underline and, the advertisement states that the person is not a licensed contractor. So there's two components. The work has to be less than $500, and the advertisement has to state that the person is not a licensed contractor. Next paragraph. There's a lot of material here in this page that is covered in the state exam, which is why I'm going through it in detail. No one may file a lawsuit in a California court for the collection of compensation for any work or contract requiring a contractor's license unless it can be proven that the business was duly licensed as a contractor at all times during performance of the work or contract, okay? So you're not paid for your work, you feel you need to file a lawsuit. The first thing, of course, that you want to consider when you're meeting with your lawyer is that your license was in good standing during the entire project, because that may be a problem when it comes to filing a lawsuit. Now, I do want to mention, it says a contractor who is licensed at the start of the project, as in quote-unquote substantial compliance of license requirements, may still file suit, okay? So when you're consulting with your lawyer, you need to make sure that the lawyer has all of the facts, the lawyer has your license history before they decide whether you can file a lawsuit. And the term substantial compliance has to do with the doctrine of substantial compliance, but that's not something that we can summarize in a page or two here. That's something you want to go over with your lawyer. And that's one area where a lawyer can come in really handy. Next, every city or county that requires building permits or business licenses must also require contractors to file signed statements. And we'll look at the declaration later, in which they list their contractor's license number and state that their license is in full force and effect. Okay, I want to just drop to the last paragraph here. This has to do with all vehicles used in a contractor's business must have the business name and contractor's license number clearly visible in letters at least 3/4 of an inch in height and width. And you might say, are they really going to ask me about that in the state exam? Yeah, some of the questions can be very specific. It also mentions that plumbing contractors, sign contractors, well drilling contractors must display their company name and business address and contractor's license number in letters at least 1.5 inches in height on both sides of the vehicle. Let's turn the page to 4. There's an illustration that you can look at to give you a little better picture of what the requirements are in terms of any signs that appear in your vehicles. Now, below that illustration, there's something else I really want you to pay attention to. Contractors must include their license number in all construction contracts, subcontracts, calls for bids, and all forms of advertising, including business cards, okay? The general rule is put your contractor's license number on everything. And if you do a radio ad, you have to mention your contractor's license number. I remember talking to a very prominent construction lawyer who told me that he advises clients to even put the license number on promotional T-shirts that they may give out with their contractor's business name on it. Just don't take any chances. And now note the next sentence in the paragraph. They must also include the following statement in prime contracts. So those are contracts that are signed directly with the owner or the agent. You've heard the expression prime contractor. They're the contractor who signed the contract directly with the owner or the owner's agent. Sometimes they're called a direct contractor, but in any event, in at least 10-point type, yes, you could get a question on that. And what they're showing here is an example of the statement. And you can see it basically introduces the consumer, in this particular case, to the contractor's state license board, mentions their function. It also mentions a couple of statutes. Patent Act or emission must be filed within 4 years. of the date of the alleged violation, and then a complaint regarding a latent act. So latent act is one that's hidden or concealed. It's not apparent from a reasonable inspection. And the statute there is 10 years. And then it gives the registrar's contact information or address. All right. Let's go to page 5. Exemptions. Now, I mentioned the minor work exemption, but there are a lot of other exemptions. And I'm not going to go through all of them. I'm going to go through the ones that you're most likely to be asked about in the exam. Now, the very first is employees who are paid wages, who do not usually engage in an independently established business, and who do not control the performance of jobs or determine the final results of work. So now we're talking about employees with wages as their sole compensation. So if you have employees, you have certain obligations as an employer. You have to withhold payroll taxes. You have to file quarterly returns with the IRS and the Employment Development Department. And at the end of the year, you have to issue W-2s. That's the employees we're talking about. We're not talking about what are commonly known as 1099 employees or independent contractors. So employees who are working for an owner-builder, that's the next exemption, or for a contractor, do not themselves have to obtain a contractor's license. The next one, owner-builders. Let's take a look at the first of 3 categories. Build or improve existing structures in their own property if they either do the work themselves or use their own employees, paid in wages, to do the work. Now note the exemption is only valid if the structure is not intended or offered for sale within 1 year of completion. So as you go through these exemptions, note any limitations because you may be asked about those on the state exam. The second one has to do with licensed subcontractors that may be contracted with by the owner-builder. Third one I really want to zero in on here, very likely to get a question, says improve their principal place of residence, their main residence, have actually resided there for 1 year prior to completion of the work and who complete the work before sale. Okay, so they don't need a contractor's license if that's the case. But again, there's a limitation. This exemption is limited to 2 such structures within 1 3-year period. Okay, before I go to the other exemptions, something that a lot of people don't know about is that where the owner-builder can pretty much do anything as long as it's on their own property, there's one class of work that they cannot do, and it could be asked about in the state exam. An owner-builder cannot drill a water well. They, by law, would have to hire a C-57 well drilling contractor. So that's one little bit of trivia that a lot of people aren't aware of. Okay, so you go through the list. Most of these things are pretty obvious. Public personnel working on public projects. I want to jump down to where it says installation or sale of finished products that do not become a fixed part of the structure. Okay. However, note this, floor covering installation does require a contractor's license, and that would be C-15, flooring and floor covering contractor, so be aware of that. The next one has to do with minor work. We already talked about that. Very quickly, another exemption that I want to cover would be operators who install, maintain, monitor, sell, alter, or service security alarm systems. They don't need a contractor's license. They're licensed by the Bureau of Security and Investigative Services. However, note, the installation of fire alarm systems does require a contractor's license, so they could not do this without obtaining, for example, a C-10 contractor's license. Bottom, you have persons registered with the Bureau of Electronic and Appliance Repair. They can install satellite antenna systems on residential property or structures, but the work is limited to that. So let's go. There's one other thing I get often asked this question. What about federal projects? Do you need a California contractor's license for that? And generally, no. The California, like any other state, cannot impose their licensing requirements in the federal government. But if you're going to take on a federal project, you've never done it before, do your homework because there are a lot of requirements you're going to have to meet as a contractor. Okay, turning to page 6, we have types of licenses. There are 4 basic license entities. You have a sole ownership, sometimes called an individual license, partnership, corporation, or limited liability company. Now, these are all discussed in a later chapter, so I won't get into them now. The thing I want to focus on, if you go to the second paragraph, it says all 4 types of licenses described here must have a qualifying individual, a QI. And the QI is the individual who has the knowledge and experience required for the license. They have to take any required state exams, and they're responsible for making sure the business complies with applicable laws, rules, and regulations. So every licensed entity requires a qualifying individual. If you look at a sole ownership, those of you who are applying for your own individual license and taking the exam, you would be the qualifying individual, the owner. However, sometimes someone who applies for a sole ownership license doesn't meet the qualifications, and what they can do is hire an employee called a responsible managing employee. So the responsible managing employee would serve as the QI. Now note that it says the RME must work at least 32 hours a week or 80% of total weekly business hours. So they can't be an employee in name only. They have to be actively involved in the business. Partnership, the QI of a partnership can be a general partner, and they're usually called the qualifying partner, or the partnership can hire an RME. Corporation, you can be an officer called the responsible managing officer, or RMO, or an RME. The LLC, there are 4 different possibilities for the QI, the qualifying individual: RME, RMO, responsible managing officer, or a responsible managing member. So any of those can serve as the qualifying individual. Let me jump down to the last paragraph. In general, a license may not be transferred. This is very important. Let's say you have a sole ownership contractor's license and you want to form a partnership and do business as a construction partnership. You have to file a new application for that partnership, just like you had to file an application for your sole ownership. That partnership is an entity separate from your sole ownership. Turn the page to 7 and look up. Talks about incorporating. Same idea. A lot of times, if you're a sole owner, your attorney may advise you to incorporate. Now, if you incorporate, then you've not only got to post articles and have bylaws prepared, you also have to file an application for a license specifically for the corporation. Below that, it says you may change the name or address of any business license without filing a new application. And it says just send the COCLB an application to change contractor name and or address or letter within 90 days. Let me tell you, it's important not to put that off. If you change addresses, you make a move, don't procrastinate, because you want to make sure that the board has your current address. Because if they send you a renewal notice, for example, for your license, and it comes back to them, well, first of all, they're going to know that you didn't change your address on time. And also, you could miss a deadline because you didn't get the notification. So be real careful about that. Don't wait 90 days. Do it as soon as possible. Let's look at license classifications. California contractors licensed are grouped into 3 main classifications. You're probably familiar with these by now if you've started to fill out your contractor's license application or if you've already completed it. There's a general engineering A contractor. They deal mainly with fixed works. Drop down to general building B contractors, work on buildings, structures that shelter people, animals, or chattel. Chattel is items of personal property like your truck or an automobile. The B license is the most popular. About a third of the contractors in California are licensed as general building contractors, and that makes more sense because it's flexible. You can go in with a B and do a kitchen remodel, a room addition, or you can build a house from scratch. There are also the specialty C contractors. I talked about them a little while ago. You have the C10, mentioned here electrical, plumbing, C36, painting, C33, roofing, C39. So they basically bid single trades. There's also at the bottom, you'll see limited specialty, C61 contractors. They're licensed in one or more of approximately 60 trades known as D subcategories. So when you think of contractors' licenses, it's A, B, C, D. A is general engineering, B is general building, C is the specialty contractors like the C10, and then you have the limited specialty, and the Ds are all of their subcategories. So, for example, a contractor who does scaffolding only would get a D39, or a contractor who just does construction cleanup would get a D63, and those fall under the limited specialty classification. All right, so going over to page 8, you can add classifications to your license. If you're a general building contractor, for example, and you want to add a C8 license, a concrete license, because you want to expand your work, you want to be able to bid as a subcontractor, for example, in some concrete jobs, then you can do that. You have to have the experience, and you have to take the trade exam. It is a misdemeanor in the second paragraph. Just want to mention this: to advertise for work that does not fall under your license classification. So be very, very careful, again, to read your license classification. Not just before you, not just after you get your license, but before you apply for the license, because you want to make sure that the work you want to do is actually covered by the license classification. Okay, the next topic is joint venture. Several contractors can get a joint venture license. This would happen where you have an extremely big job, a reservoir or something, and no one contractor has the capacity to do the work. They may not be able to get the bonds they need for the job. So what they do is they get together with other contractors and they obtain a joint venture license so they can submit a joint bid on the project, and that's what they're talking about here. All right, at the bottom of the page is the first of several fill-in exercises. This is titled Contractor's License Law Questions. And what I want to say about these came about at the suggestion of some former students. The idea is that you're reading through this material, and every once in a while you'd like a chance to stop and review and see if you're absorbing all this information. And that's what these fill-ins allow you to do. Also, we don't pick these fill-ins randomly. The staff picks out facts that you're tested on in the state examination, and they present them as fill-ins. Why fill-ins? Because they're harder. You either know the information or you don't. So I really want to encourage you to go through and fill out the answers. Now, on the next page, we give you the answers so you can check yourself, but this is really very critical. Now, later in the course, you're going to be taking our multiple choice practice exams, hundreds of them, and we use multiple choice exams because that's the format used by the Contractor State License Board. Okay, let's go over to page 9, and it talks about obtaining a license. Now, at this particular point, I'm going to kind of move through the material a little more quickly because some of this is just background material. You're not going to be asked about it specifically in the state exam. The license board realizes that if you have filed an application that's being accepted and you've appeared for the examination, you already know much of this information. So let me just have you look through it just very quickly. It mentions the notice to appear for examination. Some of you may have already received that. It mentions that you have 18 months to pass both examinations. That's from the time your application is accepted. That's a lot of time. So I don't know of anyone personally that took that long, but you do have it, and you can take the exam as many times as you want within that period. Page 10 talks about passing the exam. Again, you may already be familiar with this information just from what you looked at in preparing your contractor state license application. But you're going to get a pass letter from the state if you pass, and you have 90 days to pay the original license fee. Now, this is different from the application fee. This is the fee for, if it's an active contractor's license, it would be the 2-year license period. And also, if it's an active contractor's license, you're going to have to post a contractor's license bond. We'll talk about that a little later. Down it says a 5-year deadline. See where it says also applies to license renewal. You may renew an expired license within 5 years of its expiration date, and only a delinquency fee will be charged. So be aware of that. Sometimes contractors will just let their license expire because they want to try some other line of work that doesn't have anything to do with contracting. And then after a few years, they decide, well, there's a lot of opportunities that are coming up, and I want to go back and renew my license. Well, you can do that for up to 5 years. You pay a delinquency fee, but you don't have to go and take the exams again. Reciprocity, top of page 11. I'll just touch on this quickly. Arizona, Nevada, and Utah have reciprocity agreements. So a contractor licensed in those states can get a license in California by filing an application. They do have to take the law and business exam, but not the trade exam. That can be waived. Now we're talking about the contractor's bond. So after passing the qualifying exams or having them waived, you will receive a letter entitled Request for Bonds and License Fee. And it will ask for two things: the license fee for the initial 2-year period of an original license. That I mentioned that earlier. This would be for an active license. And then a contractor's bond or bond equivalent. That has to be filed with the Contractor State License Board within 90 days. Okay, so be prompt. You know, again, you have 90 days to do some of these things, but do them right away. The contractor's license bond, you don't want to confuse it with other bonds like a performance bond or a payment bond. And as a matter of fact, it's illegal on your truck to advertise licensed and bonded, because the public may think the bond covers more than what is actually covered by your license bond. Same with insurance. If you just say licensed and insured, it's too vague. If you mean workers' compensation insurance, you have to state that. So be careful about what you put on your truck. In general, it's just safest to put your business name, license number, and if you're in one of those 3 categories that has to include your business address, then be sure to do that. Okay, so the contractor's license bond, as it's stated at the bottom, damages must have resulted directly from violation of the contractor's license law, and the contractor's bond specifically designed to protect, and there's 4 different groups, including the homeowner. Let's go to page 12. There's a bit of a discussion we've kind of thrown in, and basically the gist of this is the Contractor State License Board will only keep 1 bond at a time on file. And what happens is, if initially you buy a 3-year bond, when you obtain your license, you forget, and the next year you file a 1-year bond. The 1-year bond is going to kick out the 3-year bond. So basically, you've lost some of the initial coverage. Let me move on. Down at the bottom, I do want to mention something. You see number 2, it says inactive licenses do not require a bond, but the license renewal fee must be paid every 4 years. So if you get a question on inactive licenses are on hold. You can't actively contract. And because they're on hold, you don't require a bond. You also don't have to have an RME, and you don't have to have any insurance like workers' compensation because you're not actively contracting. Okay, let me move on. I want to get through the rest of the chapter and cover everything that's important for the examination. Some of this, again, is kind of just general background material. We get into bond alternatives. In lieu of a bond, you could post a cashier's check with the registrar, but those aren't recommended because it ties up your money. And also, contractors' bonds premiums are very low. They're very affordable. And that's because there are so many insurance agents that are competing for your bond business. And a lot of them charge intentionally a low price in a bond because once they have you as a bond client, then they want to sell you workers' compensation, commercial general liability, commercial auto, and other types of insurance where they make a pretty good profit. Fingerprints, you probably already know about these. Let's go to page 14. license issuance. Just mention quickly that you receive from the board a pocket license that you can carry around with you and show potential customers. You also receive a wall license. The wall license has to be displayed in your main office or chief place of business. With that, we are looking at another set of review questions that you can look at, and the answers are on the next page. Next page is maintaining a license. We're talking about the renewal of a license. Top of the page, an active contractor's license expires 2 years from the last day of the month in which the license is issued. So active license, 2-year term. Inactive license is renewed every 4 years. Let me mention a continuance of a license. It says if the qualifying individual for sole ownership dies, the license is generally canceled unless a continuance or reassignment is requested. Now, this is a situation where maybe one of the members of the family who is the qualifier dies, and what is the family going to do? They have some work to complete. So they can request permission from the registrar to continue the business for a reasonable period of time. Let's go over to page 16. Okay, let's go to inactivation of a license. I've already talked about an inactive license, but I want to go through a little additional information. A contractor may inactivate a license by submitting the form application to inactivate state contractor's license along with the current pocket license. So the registrar's office will then send you a new pocket license, but it'll be marked inactive. Flip over to the next page. You have maintaining a license questions. So there starts with an active license must be renewed every, what do you think? 4 years? 6 years? 2 years. Okay, good. And again, we have the answers on the next page. Let's talk about disciplinary proceedings, page 18. The registrar may and must, if there has been a written complaint, investigate the actions of any contractor or home improvement salesperson in California and may issue a warning, a temporary suspension, or permanent revocation of any license or registration. Registration would refer to a home improvement salesperson registration. Okay, let's go to the next paragraph. This is important. All complaints against licensing alleging commission of any patent, in parentheses, apparent, obvious acts or omissions, must be in writing and filed with the registrar within 4 years of the date the act or omission is said to have occurred. So there's a statute there of 4 years that you want to be mindful of. And then take a look at the next paragraph where they're alleging commission of any latent acts or omissions regarding structural defects must be filed with the registrar within 10 years. So the statute for latent acts or omissions is 10 years. It's really important that you maintain job records for at least 10 years. And the reason for that is that you could be sued 10 years later. Latent defects, for example, aren't always discovered right away. It could be years. And if you are sued, you want to be sure to have the job records so you're able to defend yourself. Currently, contractors are only required to maintain records for 5 years, but the recommendation is 10 years, just because of potential lawsuits. Let's go over to the causes for disciplinary action. Causes for disciplinary action by the registrar include abandonment of a construction project without a legal excuse. Okay, that was what, if you go back to 1929 when the Contractor State License Board first opened their doors, they listed 4 different causes for disciplinary action. Now the list has expanded since, but this was the top of their list because that was happening a lot back then. The next one, diversion of funds or property received. That was another of the causes for disciplinary action. It was on their 1929 list. Let me drop down. Failure of a prime contractor to pay subcontractors within 7 days of receipt of each progress payment, okay, unless there's a written agreement to the contrary. So this is the law. The old law used to be 10 days, but then, I think it was back in 2010, the legislature decided to shorten it to 7 days. So 7 days is the current requirement. Let's look down. We've got willful departure from or disregard of plans or specifications. That's a cause for disciplinary action. And then I want to look at failure to keep records showing all contracts, documents, records, receipts, and payments by a licensee of all transaction as a contractor, or failure to have such records available, etc. And notice it says for at least 5 years after completion of any project. So I mentioned that before, but the recommendation is to keep them for 10 years. You're only required to keep them for 5 years, but keep them for 10 years. Let me have you look through the others. Okay, let's go to page 20. I want to point out a couple of other things. Drop down, it says acting in the capacity of a contractor under an inactive, suspended, or expired license. That's cause for disciplinary action. Entering into a contract with an unlicensed contractor in a situation in which a license is required. You really want to be careful as a general contractor to make sure that anyone who submits a bid to you as a subcontractor, that they are licensed and that their license is in good standing. You'd be surprised with how many contractors have obtained the license number of a subcontractor and then looked up the license history on the Contractor State License Board website and discovered that the license is expired or it's been suspended, for example. They may not have posted a bond, any number of things. And you want to be very careful to check the license status of any subcontractor, because you don't want to be accused of entering into a contract with someone who's not properly licensed. The last one, a home improvement contractor employing an unregistered person to solicit or sell home improvement contracts. So they're referring there to home improvement salespersons. You'll be hearing about them in a later chapter. We have citations. What I want to have you do is drop down here. If you are issued a citation by the Registrar of Contractors for a violation of the contractor's license law, you have a right to appeal. And it says a licensee served with a citation may appeal to the registrar for a hearing within 15 working days from service of the citation. You only have 15 working days. Be aware of that. So you don't want to procrastinate. There's a form that you can fill out to preserve your right to appeal. Do it right away. And remember, it's 15 working days. That's a potential exam question. A lot of the time periods we've seen are 90 days. Not so when it comes to an appeal. Page 21, disciplinary proceedings questions. And again, it's a good review with fill-ins that the staff has selected because they represent facts that are often covered in the contractor state license exam. Let's go over to dispute resolution, page 22. First of all, it says prevention. The best way to handle a dispute is to prevent one from occurring. And that's really the best advice. You want to make sure that everything is reduced to writing. If there are change orders, they're reduced to writing. You want to make sure that the property owner has a very clear understanding of what they're getting and what they're not getting. The arbitration. Now, this is interesting. The Contractor State License Board offers 2 arbitration programs. One is mandatory and the other is considered voluntary. And so if a consumer files a complaint with the board and it's reviewed by a licensing deputy and determined to be valid, one of the things the registrar can do, if the complaint mainly has to do with a change order dispute or some other contractual dispute, or if it has to do maybe with the workmanship, the work covered, then they can refer it to arbitration. Now, arbitration is great as the Contractor State License Board programs goes, because normally if you do private arbitration, you have to pay the arbitrator and you have various other costs that you have to pay. But the CSOB arbitration program is free. They pay for the arbitrator. They pay for any administrative expenses. And they'll even pay for one expert witness who may appear during the arbitration. So and from a contractor standpoint, it's a good idea because arbitrations aren't disclosed in the public record. Nobody knows that you're in arbitration. And that is an incentive for a lot of contractors. But if you are ever called to do an arbitration, you want to go ahead and comply. Now, they use the terms mandatory and voluntary arbitration. Mandatory means you don't have a choice. The registrar can order you to arbitration. And that's where the damages are relatively minor. The damages are less than the amount of your contractor's license bond. Now, there's the voluntary arbitration program, and that's where the damages exceed the contractor's state license bond up to a certain amount. And then the contractor and the complainant, the homeowner, can decide to participate in arbitration or not to participate in arbitration. But again, it's free. So unless you have another route that you want to go, it's something that is highly recommended. Page 23, it talks a little more about the arbitration. It mentions the fact that it's free, as I've stated. Small claims court is a popular option for contractors and consumers when you have relatively minor agreements, uncomplicated agreements. It does have a limit, and it only covers money damages only. So the court, in other words, if a contractor has recorded a mechanic's lien, and you'll be hearing about those later, they cannot foreclose on the lien in the small claims court. Some of you have probably already had experience with small claims courts. So I don't really probably have much to add other than what's here. The decisions in small claims court are appealable. So if a defendant loses a case, they can appeal to the Superior Court. Let's go over to page 24. Civil court lawsuits. This is where you have a complicated complaint and you're also dealing with a large sum of money. And in this particular case, you'd want to consult a lawyer. Okay, at the bottom, if you do go to court and have a civil judgment entered against you, you must send a copy of the judgment to the CSOB within 90 days of the judgment date. So if a judgment is entered against you, you have to report it to the Contractor State License Board. Okay, the next topic is federal district court. You probably won't be involved with the federal district courts, at least most of you. If you're going to file bankruptcy, then that would come under the jurisdiction of the federal district court. But let's think positive. And page 25, you have some questions you can fill in. Let's go to construction standards. You have building permits. We all know about those. And then below that, you have the Health and Safety Code. And we talked earlier about having to file a declaration when you want to pull a building permit. And here's an example of a licensed contractor's declaration. Let's go over to page 27, California accessibility requirements. You may get a few questions, 2 or 3 questions about this on the law and business exam. What I want you to do is drop down to the second paragraph. Access requirements adopted by OSA, that's the Office of the State Architect, and HCD, Department of Housing and Community Development, are contained in Title 24 of the California Code of Regulations, okay? Next sentence is important. In general, California's Title 24 requirements are more strict than the federal Americans with Disabilities Act or the ADA requirements. So be aware of that when you're retrofitting. Make sure that you're conforming to the strictest set of requirements. The next paragraph mentions the path of travel. Let's start with the second sentence. When retrofitting, access requirements apply only to the area of alteration, structural repair, remodel, or addition. In other words, it may not be necessary to bring the entire building up to access standards. However, and this is important, a path of travel to the retrofitted area must be compliant. You'll probably be asked about that. And also, next to the last paragraph, all accessible levels of privately funded, newly built apartment buildings of 5 or more units must be adaptable for disabled persons. And here they define accessible level means any area that can be reached by a ground level entrance or a ramp or an elevator. So be aware of that if you're doing new construction of apartment houses. Page 28 talks a little bit about parking facilities, the dimensions and the numbers of parking spaces designed for disabled. In general, the ratio is 1 to 40. If you have 40 parking spaces, at least one has to be an accessible space. If you have 120 parking spaces, again, the ratio is 1 to 40. You'd need to have 3 accessible spaces. Underground service alert. Now, this is something I think you're probably familiar with. The dig alert. Drop down to the second paragraph. Excavators must mark the area to be excavated before contacting the Regional Notification Center, dig alert in Southern California, USA North in Central or Northern California by dialing 811. Okay, so they have to be notified and you have to be given an identification or ticket number. And as we all know, that PG&E, one of the utilities, will come out and they'll look to see if there are any underground utility lines, and they will mark those. And the whole purpose is they don't want you damaging them. And I want you to look at the chart, color, underground service line. You may get a couple of exam questions. For example, the question may say that you have an underground sewer line. What would be the color code? And green. Now, you may be familiar with some of these, blue for water, for example, but just look through it quickly, and if there's anything you're not familiar with, you want to commit that to memory, because they could ask you specific questions. Top of page 29, abandoned underground service lines must be marked and have an A inside of a circle to indicate it is no longer in use. Jump past the paragraph and it says failure to contact the Regional Notification Center can result in fines up to $50,000, and you could be charged with repair costs of damaged underground facilities, and look at this, you could have your license revoked. So I can't emphasize the importance of complying with these rules. Don't take any chances because you can be in hot water if there's a violation. Okay, page 30, we have a list of the steps to a safe excavation. Number 2, again, you're probably familiar with this. Call 811 before you dig. Call the Regional Notification Center 2 working days to 14 calendar days before you dig. 2 working days would be the minimum. Okay, that could be asked about in the state exam, so make sure you understand that. There's the gray box. As you notice, it says a ticket is active for 28 calendar days from the date of its issuance. You must have an active ticket for the entire duration of your excavation. So if the ticket expires, but you have to continue working, then you must call and get a new ticket and wait a minimum of 2 working days. Be aware of that. Page 31, I'll point out something that might be covered in the exam. Dig with care, hand excavate within 24 inches tolerance zone of the outside diameter of the facility. So 24 inches is a number you want to remember. Let's drop down to Native American remains. It's highly likely that you're going to get a state exam question in this. It's really important. So it reads, if during excavation you unearth human remains or burial artifacts anywhere outside of a cemetery, you must stop work immediately at that site and any other nearby area that you reasonably suspect to have remains, okay? So you have to stop work immediately, and you also must immediately contact the county coroner. So that's most likely an exam question. And if you drop down, it says, if you unearth artifacts that do not include human remains and are not associated with burial grounds, you must stop all work within a 60-foot radius of the discovery. Set up fencing and otherwise protect the discovery area, and then you need to notify the project engineer, the owner's representative, and so they can investigate it. So be aware of that. Next page, 32, more filling questions. Be sure you go through these and check your answers. And if you miss one of the questions, go back and review the relevant portion of the manual. Make sure you will remember this for the state exam. Page 33 talks about environmental impact of construction activities. So what they're concerned here is any construction work that would have a significant impact on the environment. Now, this information that we're getting into here is something we've added. It's probably not going to be the focus of the contractor state license exam, but you may get a question on it. So we want you to be completely prepared, and that's why we're adding it. And it's just a couple of pages you can read through real quickly. I want you to jump down to the last paragraph now, and it reads, construction activity resulting in a land disturbance of 1 acre or more, or less than 1 acre, but part of a larger common plan of development or sale, requires the construction activities storm water general permit. So that could come up in the state examination, and I want you to highlight that. Let's go over to page 34. We're talking about the California Coastal Commission, sometimes referred to as the CCC. I don't know how many of you have heard of Sea Ranch. That's a development along the coast of Sonoma. And back in 1972, when it was being developed, there was big concern among the local residents that these shoreline developments, in this case was going on for 10 miles, was going to effectively privatize too much of the coastline, and that was going to deny people public access. So there was a voter initiative called Proposition 20, and the result of it is that the California Coastal Commission was created. And if you look down, it says the California Coastal Commission plans and regulates the use of land and water in the coastal zone of California. And it mentions the major goals. Look at the first one, to maximize public access and recreation. And that's, again, that was the voters who pushed that. There's a sentence that says some coastal cities and communities have developed their own local coastal programs, LCPs. You may see that abbreviation in the state exam. That's what they're referring to. The other thing that I want to mention over in page 35, it says the Coastal Act, be aware of this, defines development broadly to include, among other things, construction of buildings, divisions of land, and activities that change the intensity of land use or public access to coastal waters, even where no construction is involved. So it's a broad law. This doesn't have to do with building. Okay, so now turning to page, we're at 36. This begins our Chapter 1 glossary of terms. A lot of people don't even look at the glossary, but I highly recommend that you go through it and make sure you understand the meaning of each term, because you don't want to run across a state exam question where they use a term you're not familiar with and where you'd have to guess at the answer, whereas you might have known the answer if you understood the term, you knew what they were talking about. So as you go through this, check off any terms that are new, and then maybe a couple of days before your actual state exam, you might want to review them so they're fresh in your mind. And speaking fresh in your mind and looking at material 1 or 2 days before the state exam, I want to move back to the beginning of the manual. We're outside Chapter 1 now, and this is my final set of comments. I go back. Do you see where we have summary of deadlines? The page is Roman numeral VI. Okay, now what the staff has done is they've gone through the different laws and regulations And they've listed all of these deadlines: 3 business days, 10 days, 15 business days, 90 days. And what they've done here is created a list that you can review 1 or 2 days before you take the state exam. The state is going to ask you about deadlines, and they're going to ask for a number of days. The questions will be very specific. So in the license law, here are the deadlines that you need to know for that portion of the examination. You can also see listed are the deadlines for the mechanics lien law. And we have a chapter in that later. There's also a lecture. And if you flip the page, you also have deadlines for the labor code, and then there's additional information on summary of penalties and things like that. So these pages are, again, for your review just before you take the state examination, because it's hard to remember all of this as you go through the chapters. And we know that you need a chance to sit down, focus on them, get them fresh in your mind, so you can answer all the related state exam questions. And I wanted to point that out. Okay, that concludes my lecture, and good luck to you.
Hello, my name is Timothy Hannon. I'm a lawyer based in Santa Rosa, California. That's about an hour north of San Francisco. And it is my fortunate task to guide you through Chapter 2 of your law manual, the chapter on contracts. Let's begin at page 1 with some observations about all contracts, whether they're construction contracts or otherwise. A contract is a legally binding agreement between 2 or more parties that creates certain obligations. More simply stated, it's an agreement that's enforceable in a court of law. That's what a contract is. A contract may be oral or written, although written is much better. If you reduce your contract to writing, of course, it avoids misunderstandings about what a job will or will not include. Just as a house needs a solid foundation, likewise, a business deal needs a clear, thorough contract on which it is to be based. It's basically, in shorthand, a meeting of the minds of the parties. And we're here on page 1, we have the 4 essential elements of any contract explained here. The first of the 4 is mutual assent. This comes down to an offer and an acceptance of the offer. There must be a clear, definite offer, and there has to be an unqualified acceptance. For example, the contractor will say to the owner, I promise to build your house for you according to certain approved plans and specifications, in return for which you will pay me $300,000. I'll be finished with the project in 3 months. If the owner says yes, without any qualifications, we have a deal. That's a contract, an agreement enforceable at law. If, on the other hand, the owner were to say, okay, but I want to reduce the contract price by $10,000, or okay, but I want the project to be finished in 2 months rather than 3. That's not an acceptance. That, in effect, is what lawyers call a counteroffer. So when you're making a contract with whoever your customer may be sure that there's an unqualified acceptance of your offer. Yes, with no conditions, no qualifications. The next element of a contract is what the law calls consideration. That's a fancy word for something of value. There has to be an exchange of values in order for there to be a contract. It can't be one-sided. Each side has to offer something of value. Typically, in the construction world, a promise is exchanged for a promise. Promise to build in exchange for a promise to pay. The third element is capacity, which means capability of understanding the terms of the contract. Parties must be of legal age, that is to say, 18 years of age or older. They have to have sufficient mental capacity to understand the meaning of the words in the contract, and they must not otherwise be impaired. For example, too sick or too intoxicated to understand the transaction. The fourth essential element is a legal purpose. purpose of the contract cannot violate the law. For example, a contract to sell heroin or crystal meth would be unenforceable because, of course, those substances are illegal. A contract to build a house is not enforceable if the contractor doesn't have a license to be a contractor. So those are the four essentials of any valid contract: mutual assent, offer and unqualified acceptance, consideration, that's exchange of a valuable promise for a valuable promise, capacity, meaning both parties have to be capable of understanding the terms of the agreement they're making, and finally, legal purpose. Or more precisely stated, the purpose of the contract cannot be illegal. The next paragraph is about void contracts. A contract may be void because it's against public policy or illegal. If the contract is illegal, the law treats it as if it had never been made. The courts just leave the parties where it finds them. A voidable contract, you want to highlight this now, at the bottom of page 1. A voidable contract is valid and enforceable on its face, but may be set aside or rejected by the injured or wronged party. For example, contract may be obtained through duress or fraud or menace or undue influence or mistake. These are all contracts that may be voided, but not necessarily will be voided by the injured party. In other words, the party wronged by the fraud or the duress can still say, I want the deal anyway, even though I was wronged. On page 2, we have some guidelines for writing construction contracts. There's a lot of good advice on this page 2. The first piece of advice is to be as specific as possible regarding the details of your scope of work. For example, it wouldn't be enough merely to write replace kitchen faucet. Rather, you'd want to say, or write, I should say, replace kitchen faucet with brand X faucet in style or model 22B, color platinum. That kind of detail. Or not just merely install a furnace, but rather install forced warm air upflow furnace with single-phase electric blower motor with permanent split capacitor, manufactured by KLM Corporation, model number 1234. That's the kind of specificity that will make your contract fully enforceable. Avoid problems in the future. Next guideline, review the contract line by line with the owner. This is also very important. You need to make sure that the owner understands the terms of the contract that you're making with him. And tedious as it may be, it's a very good habit to get into. Review the contract line by line with the owner. Next guideline, discuss change orders with the owner at a pre-construction meeting. Make sure to put all changes to the contract in writing. I would add to this, if you're going to do any extra work, get the change order written and signed by the owner before you even begin to do any extra work. If you wait till after you've done the extra work, the owner might be much more reluctant to sign the change order because, frankly, he won't need you anymore for that extra work. In fact, I'd go so far as to say, if you don't get a change order for extra work before you do the extra work, it's like putting a sign on your back that says, kick me. Take advantage of me, because I don't know what I'm doing. You certainly don't want to convey that impression to the owner. Next guideline, you want to highlight this now. Many construction contracts will include a disclaimer stating the contractor is not responsible for delays caused by weather, earthquakes, floods, or other acts of God. It's important that you include that clause in your contracts. Next guideline, a personal guarantee may be used in contracts with renters or lessees. A simple statement such as the agent is liable for final payment will require the person who signs the contract to be personally responsible for the payment. Yes, indeed. If you're working for a renter or a lessee, you want to be sure to put that clause in your contract so there's no question about who's supposed to pay you. You want to highlight also on page 2, about 3/5 of the way down the page, the wording as follows. Under California law, if a contractor includes a provision for private arbitration in a printed contract for work on residential property with 4 or fewer units, it must be set out in at least 10-point Roman boldface type, or in contrasting red print in at least 8-point boldface type. In the case of a typed contract, it must be typed in capital letters. With respect to this boldface type business, you want to pay particular attention to the 10-point Roman boldface versus red print in at least 8-point boldface. This is a technical point, of course, but it comes up a lot on the license board's exam. So be mindful of that. Moving on, at the bottom of page 2, we have mention of pre-printed contracts. I think that pre-printed contract forms are usually a good place to start in drafting a contract. They're not the end point. In my experience, I have yet to see a construction project that fits neatly all its terms within the 4 corners of a printed contract. Invariably, printed contract has to be modified somehow. Things deleted, things added, in order to tailor the contract to the needs of the particular job at hand. But the printed contract form is a good place to start because often it will anticipate and solve issues that might otherwise be overlooked by the parties when they're making what might be called a homemade contract. So I strongly favor printed contract forms. Over on pages 3 and 4, you are offered an example of a prime construction contract. This particular printed form is published by BNI Building News. You can contact BNI Building News to obtain a family of printed forms. You can find the contact information for BNI Building News immediately before page 1 of this chapter 2. Beginning on page 5, we have some information about home improvement contracts. This is a special body of laws that pertains expressly to a special situation. The situation being where the contractor is called upon to do repairs or remodels, some sort of improvement to an already existing residence. Not new residential construction now, but an already existing residence where the contract price is over $500. At the top of page 5, you'll want to highlight the sentence, "A home improvement contract and any changes made to that contract must be in writing." The next sentence to be highlighted reads, "Home improvement means the repairing, remodeling, altering, converting, modernizing, or adding to residential property." Again, it's improving already existing property somehow. Paragraph 3 begins, and you should highlight, "No separate license classification exists for a home improvement contractor." Right. The home improvement contractor could be a carpenter, a general building contractor. It could be a plumber, electrician, a landscaper. It could be a general or any specialty contractor, as long as he has a direct contract with the homeowner or the tenant to do a repair or remodel or some other kind of improvement. Halfway down the page, we have information about home improvement salesperson. A home improvement contractor, whatever his trade may be, can hire someone to drum up business for him, a home improvement salesperson, in which case the salesperson has to be registered with the Contractor State License Board as the salesperson for that contractor. In other words, the license board has to be notified that the home improvement contractor is using a salesman to find him business. The sentence at the bottom of page 5 needs to be highlighted. It says, "Like an active contractor's license, a salesperson's registration expires 2 years from the last day of the month in which it was issued." So the registered salesperson's registration has to be renewed every 2 years, just as the contractor's license has to be renewed every 2 years. At the top of page 6, you want to highlight the sentence, "Salespersons are not allowed to receive compensation from anyone other than the contractor with whom they are registered." Moving down to elements of a home improvement contract, the first sentence in that section reads, and should be highlighted, "Every home improvement contract and any changes to the contract must be in writing and signed by all the parties before work begins." Very important sentence there. And if the job requires plans and specifications, and most of them do, it's important for the contractor and the owner, or I should say the buyer, to review those plans and specifications. I would say this also, the plans and specifications, once they are approved by the city or county officials, should be incorporated by reference right into the contract terms. That way there's no mistake about what the scope of the contractor's work is going to be. At the top of page 7, we have further requirements of home improvement contract law. Every home improvement contract must include the name and address and license number of the contractor. You want to highlight this now. The name and registration number of any salesperson who solicited or negotiated the contract. The contract price in dollars and cents. This bears some explaining. Home improvement contract law holds that the contract price must be a fixed price. It has to be stated in dollars and cents. This is often troublesome to home improvement contractors because oftentimes before a repair or remodel job begins, the contractor doesn't know what hidden conditions there may be inside the structure. So he cannot protect himself by making a contract price that's determined by time and the cost of time and materials, nor can he make a contract price that's determined by costs of the project plus some percentage of those costs, cost plus contract. Those are not available to the home improvement contractor. But there are some things the home improvement contractor can legally do to protect himself against unforeseen problems, unforeseen conditions in the property. For one thing, he can make not one but two contracts. First, a contract for demolition at a fixed price, and second, the main contract for the actual repair or remodel that the owner wants. Once the demolition contract is performed, the contractor is going to know pretty well what conditions he's facing inside the structure, and then he can make a better informed main contract with the owner. The other thing that the home improvement contractor can do to protect himself against unforeseen conditions is to put a lot of exclusions into the main contract. For example, this contract excludes any repair work necessitated by the discovery of dry rot, something like that, some kind of an exclusion like that. Those two are useful to the home improvement contractor in protecting himself against unforeseen conditions. What else? What else? A description of the work to be done and materials, equipment to be used. You should highlight a swimming pool also requires a plan or scale drawing showing the shape, size, dimension, and construction specifications. Well, I would say it's a good idea to make scale drawings if you don't have a architecturally drawn set of plans. At least make a scale drawing of just about any project you're going to take on. The more detail, the better, I would say, in general. It avoids misunderstandings later on. You also have to include in the home improvement contract the amount of the down payment, plus a statement and at least 12-point bold-face type, quote, the down payment may not be more than $1,000 or 10% of the contract price, whichever is less, end quote. This clause came about, in fact, the whole home improvement contract law came about because of many abuses by unprincipled contractors who would typically do something like this. They'd meet with the homeowner, agree to do a remodel or repair job, and require, say, 50% of the contract price down. The homeowner would gullibly pay the 50% of the contract price to the contractor, and he would never be seen or heard from again. To minimize that kind of abuse, the legislature has included this clause, or this requirement, I should say, in every home improvement contract. Down payment can be no more than $1,000 or 10% of the contract price, whichever is less. What else? A payment schedule showing the amount of each payment in dollars and cents. Well, that's consistent with the dollars and cents expression of the contract price overall. Furthermore, other than the down payment, the contractor may not collect payment for work not performed or materials not delivered. In other words, the payments, the progress payments, have to stay even with the progress the contractor is making on the job. Also, the home improvement contract has to state approximate dates when work will begin and be substantially completed. I would add to that that work has to begin within 20 days of the approximate start date stated in the contract. In other words, the contractor can delay starting by as much as 20 days from the date he says he's going to start, but no more than 20 days. Also, the home improvement contract has to include a notice regarding changes with the heading Note about extra work and change orders. You'll find an example of a change order form on pages 14 and 15 of Chapter 2. Also, the statement that the contractor carries commercial general liability insurance or, in the alternative, does not carry commercial general liability insurance. You'll have more detail about insurance in Chapter 5, but just briefly let me touch on this commercial general liability subject. Just in a nutshell, a commercial general liability insurance insures the contractor against what the insurance people call resultant damage, best explained by way of an example. Let's say that a roofing contractor is hired to construct a new roof. And he does so, but come the next rainy season, the roof leaks. And the leaking rainwater drips down into the interior of a room with some expensive computer equipment, or maybe heirloom collectibles or something. And the dripping rainwater ruins that personal property inside the house. The commercial general liability insurance policy would cover the contractor for the damage to the computer equipment or the heirloom carpet or whatever it is. Commercial general liability insurance would not insure the contractor for what it costs to repair the roof. So that, in a nutshell, is an explanation of what commercial general liability insurance covers and does not cover. The last requirement for the home improvement contract is a statement that either a contractor has workers' compensation insurance or is exempt from having workers' compensation insurance. What's the difference? If the contractor has any employees, even part-time employees, he needs workers' compensation insurance. If he doesn't have any employees, he does not need workers' compensation insurance. And the contractor himself is not considered an employee. He's part of management. So he doesn't need to get workers' compensation insurance on himself. If you're going to be hiring just occasional laborers every now and then, maybe one day a week or 3 days a month, something like that, rather than go to the expense of buying a workers' compensation policy, which typically lasts for a year, instead you might do better to go to a temporary employment agency and hire a temporary worker out of the employment agency. The employment agency will deduct payroll taxes and cover the worker for workers' compensation and so forth. That temporary worker will be technically considered the employee of the temp agency, not you personally. So, a word to the wise, a way to save money if you're only going to be employing occasional laborers. On page 8, we have a few more requirements of home improvement contract. Specifically, a statement informing the buyer that an extra work order or change order is not enforceable against a buyer unless the order identifies all the following in writing before the work begins. Number 1, scope of the extra work. Again, it's very important that you specify in detail what the scope of the extra work is so that there's minimal chance of there being a misunderstanding as to what you're being hired to do extra and what you're not being hired to do extra. Number 2, the amount to be added or subtracted from the contract price. Again, that has to be in dollars and cents. Number 3, the effect the order will have on the progress payments and the completion date. Also, you want to highlight this, mechanics lien warning, explaining the state's mechanics lien laws and the rights and responsibilities of an owner and a contractor. You'll find an example of that on page 11 of Chapter 2. Also, you need to include a notice regarding information about the Contractor State License Board. Highlight that. And finally, highlight notice of cancellation must be included if the contract is not negotiated at the contractor's normal place of business, such as his office or showroom or shop. You've got a good example of a home improvement contract on pages 9 through 13 of Chapter 2. And on pages 14 and 15, we have a good example of a home improvement change order form. So if the owner wants to change the contract, this is the form to use to spell out the changes in the work and the changes in the price and the changes in the completion date. And I think that pretty well covers home improvement contract law. Let's move to page 16 now. At the top of page 16, we have a comment about joint control. You should highlight the first sentence of that paragraph reading, "A joint control addendum is an agreement that allows a joint control company to act as an escrow agent that manages the distribution of payments and requires contractors to supply lien releases as progress payments are made." Joint control is a pretty good idea oftentimes because it serves as a nice, convenient clearinghouse, you might say, between the owner and the contractor for keeping track of the progress on the job versus payments made for the progress. Violations. A violation of a home improvement contract can be both a misdemeanor and a cause for disciplinary action. Yeah, you certainly want to abide by all the parts and features of the home improvement contract law. Otherwise, you may be putting yourself at a bargaining disadvantage with the owner of the home improvement project or the tenant that's hiring it to be done. You want to highlight the following paragraph, very important. It's the second paragraph under the heading violations. It reads, "A salesperson is not permitted to induce buyers to enter into home improvement contracts by promising them a kickback or credit against their contracts for any customers the buyers refer to the contractor, nor are contractors and subcontractors allowed to give compensation to each other. However, a contractor or salesperson may give a gift to a prospective customer for the purpose of advertising or sales promotion if the gift is not conditioned upon obtaining a contract for home improvement work, the gift does not exceed a whole $5 in value, and the gift is the only one given in connection with a particular transaction." For some reason, that is often included in the law exam by the Contractor State License Board, so take particular note of that paragraph. Let's go now to page 18, where we have information about home solicitation contracts. You want to highlight the first sentence. Many home improvement contracts are also home solicitation contracts. You should not confuse the two, however. The home improvement contract, as we've seen, is part of contractor's license law, which is in turn part of California's Business and Professions Code. The home solicitation contract, on the other hand, is to be found in California's Civil Code. So these are two separate sets of laws. We've already covered the features of home improvement contract law. Now I want to explain to you about home solicitation contract law. The home solicitation contract law came about because California legislature was recognizing abuses by door-to-door high-pressure salesmen. Imagine, if you will, a little old widow lady alone in her home, and along comes a slick high-pressure salesman, knocks on her door, intrudes his way into her living room, and barrages her with a high-pressure sales pitch to buy a vacuum cleaner or whatever, home improvement maybe, kitchen remodel. The poor lady doesn't, or didn't, I should say, did not have anywhere to escape from. She was literally backed up against her own living room wall. Now, thanks to home solicitation contract law, that little old widow lady, beset by the high-pressure salesman, can escape into the 3 days following the salesman's visit to her living room. So that's the basic idea behind home solicitation contract law, to give the besieged homeowner an escape route from a contract she may have remorse about having signed. You want to highlight also the last sentence of the first paragraph, which reads, if a home improvement contract is made at any place other than the contractor's usual place of business, all the laws concerned with home solicitation also apply to that particular home improvement contract. So the theater of applicability of the home solicitation contract law has been expanded from just the buyer's home, or living room in my example, to anywhere other than the contractor's place of business. In other words, if the buyer comes to the contractor's place of business, he's fair game for a high-pressure sales pitch. But anywhere else outside the contractor's offices, home solicitation contract law applies, including, most importantly, its provision that the buyer can cancel the contract anytime within 3 days after signing it. You want to highlight the first sentence in paragraph 3, which reads, the buyer's agreement or offer to buy the goods or services involved in a home solicitation contract must be written in the same language in which the sales presentation was given. In other words, if the sales pitch is given in Spanish, then the contract has to be written in Spanish. Also, in the third paragraph, it says the home solicitation contract has to be dated, signed by the buyer, and contain or have attached a 3-day right to cancel notice. You have an example of the 3-day right to cancel notice on the next page, page 19. This is the instrument, the means by which the besieged buyer can choose to cancel the contract, if he or she chooses to do so. Further on page 19, second paragraph, you want to highlight the words, for a home solicitation contract, a business day is defined as any calendar day except for Sundays and the following business holidays, New Year's Day, Washington's birthday, and so forth. Also, you want to highlight the next sentence, which reads, except in the case of an emergency, the seller of a home solicitation contract must refund any payments to the buyer within 10 days of a cancellation. The buyer, in turn, must return all goods received in the transaction within 20 days. Bit of an imbalance there. Upon cancellation, the seller of the contract, the contractor, has to refund the buyer's money within 10 days, but the buyer gets 20 days within which to return whatever goods he or she may have purchased. Now, it's important also to note that the right to cancel does not apply to an emergency situation. For example, if in an emergency the homeowner calls upon a plumber to come out and fix a bad leak or a burst in the pipe, and the plumber is presented with a basement with a basement full of water, a foot deep and deepening, it will hardly do for the plumber to wait 3 days to see whether or not the owner is going to cancel the contract. It's an emergency situation. Likewise, if the owner ushers an electrician into his living room and the chandelier is shooting sparks all over the room, clearly the electrician is not going to wait 3 days to see whether or not the owner cancels the contract. In those emergency situations, it is sufficient for the contractor to write into the contract the nature of the emergency and have the homeowner sign or initial the note about the emergency and the fact that the homeowner is waiving his 3-day right to cancel given the emergency situation. Over on page 20, second paragraph on that page, you want to highlight the following sentences. it is illegal for a contractor to raise prices more than 10% for 180 days following an emergency declaration. For example, if the governor of the state declares an emergency because of, say, a forest fire or a flood or something of that sort, contractor can't raise his prices more than 10%. In other words, he can't price gouge. At the end of that paragraph, it reads, in addition, a buyer has a right to cancel a home solicitation contract until midnight of the 7th, extended from the 3rd, 7th business day after the agreement or offer was signed. So, if the governor declares an emergency, it extends the right to cancel from 3 days to 7 days. The second half on page 20 has some comments about the Truth in Lending Act, which is a federal law passed in 1968. It defines a homeowner's right to cancel a contract within 3 business days if the contract requires a security interest in the homeowner's real property. The situation here is where the contractor takes payment in the form of a promissory note secured by a deed of trust against the homeowner's property. In that event, Regulation Z, this Truth in Lending Act, applies, and it says that in such a situation, the homeowner has 3 days to decide to cancel the contract. California law expands on this federal Truth in Lending Act by providing that the 3-day right to cancel extends to contracts where obtaining a loan is a condition of the contract, or the contractor provides financing, or the contractor refers the buyer to a lender or a loan broker. In those events, according to California law, the 3-day right to cancel is extended. Let's turn to page 22, service and repair contracts. The idea here is that a small project costing $750 or less, frankly, does not warrant the detailed, elaborate, full-fledged home improvement contract. So the law allows small contracts like this to be much briefer. The elements of a service and repair contract are set forth here on page 22. The contract price has to be $750 or less. You want to highlight these elements. The prospective buyer has to have initiated the contract. In other words, the buyer has to have gone to the contractor to get the work done, not the other way around. Next, the contractor doesn't sell the buyer goods or services beyond those reasonably necessary to take care of the particular problem for which the owner hired the contractor. And finally, the contractor is not to be paid until the work is completed. In other words, the owner doesn't pay for the project until it's over with. Even if one of these conditions is not met, just one of them is not met, then the situation reverts to requirements of home improvement contract law, which is a 4 or 5 page contract rather than just a brief 1-page contract. On page 23, we have further elaboration about service and repair contracts. There's a couple of important differences between a home improvement contract and this smaller, tidier service and repair contract. For one thing, the service and repair contract may be estimated by a time and materials formula. The estimated contract amount has to be stated in dollars and cents, but it can be an estimate, and it can be based on time and materials, not fixed price. Also, the service and repair contract has to include the following statement, quote, "The law requires that the contractor offer you any parts that were replaced during the service call. If you do not want the parts, initial the checkbox labeled OK for contractor to take replaced parts. That statement must be followed by an appropriate box for the client's initials." And finally, you should highlight the next to last bullet point there. The right to cancel a service and repair contract ends when work starts. In other words, there's no 3-day right to cancel. And that, I think, about covers it with respect to service and repair contracts. All right, we are on page 24 now. At the top of the page is the heading Residential Construction Contracts. Residential construction contracts include contracts and any changes in contracts for the construction of a single-family dwelling. Such a contract has to be in writing if the dwelling is going to be kept by the owner for at least 1 year. We're talking about new residential construction now as opposed to home improvement contracts. And the law on that is that the new residential construction contract has to be written, and the writing has to include the name and address and license number of the contractor, the approximate dates when work will begin and be substantially completed, a legal description of the property, a mechanic's lien warning, such as that shown on page 11, a statement that emphasizes the value of commercial general liability insurance. I explained that earlier in this lecture, the coverage against resultant damage, and a notice in at least 10-point boldface type that the owner has the right to require the contractor to have a performance and a payment bond, and that the expense of the bond may be borne by the owner. Performance and payment bonds are explained in more detail in chapters 3 and 6. Under the subheading Construction Defects, we have a number of very specific standards listed in the Civil Code applying to certain components of the new residential construction, including all those listed here at the bottom of page 24. Moving on to page 25, for most construction defects, a homeowner may file suit up to 4 years for patent defects, that is to say, defects that are apparent upon inspection of the construction project. And the statute of limitations for latent defects is 10 years. A latent defect being a defect that's hidden, not readily apparent upon inspection of the building. Typically faulty wiring inside the wall. Some specific defects have a more limited time frame, however. You want to study this on page 25. This law, these particular limitations periods are from a recent piece of legislation commonly known as Senate Bill 800, and they spell out certain specific limitations periods. For defects relating to paint, it's 5 years after the close of escrow. For defects relating to plumbing and sewer issues, 4 years after close of escrow. Cracks in concrete flatwork, 4 years. Corrosion of untreated steel fences, 4 years. Decay of untreated wood posts, 2 years. Dryer ducts, 2 years. Landscaping, 2 years. Irrigation systems, 1 year. I don't know how the legislature derived all those specific limitations periods, but they are indeed the law. And we move on to fit and finish requirements. You want to highlight certain sentences in here. I'll quote them for you relating to fit and finish requirements. For defects in new construction of single-family dwellings, the Civil Code requires a contractor to provide a homeowner with an express limited warranty for at least 1 year, covering the fit and finish of the following building components: cabinets, mirrors, flooring, interior and exterior walls, countertops, paint finishes, and trim. A 1-year warranty is automatically created for these components by law, even if the contractor does not provide a written warranty. And finally, at the bottom of page 25, highlight the following words: a homeowner must notify the contractor of the defect in writing by certified mail, overnight mail, or personal delivery before the owner may file an action in court. In other words, the owner has to give the contractor a reasonable opportunity to fix whatever is allegedly wrong on the contractor's own resources, rather than hurrying down to the courthouse and filing a lawsuit. Let's move on to page 27. The heading there is Public Works. The first subheading is competitive bidding. Any project over a certain dollar amount in a contract price must be put out to competitive bid for a public works job. The price limit of the contract varies from public agency to public agency. So you need to check with a particular public agency to find out whether or not the project is big enough in dollar amount to be required to be put out to competitive bidding. The purposes of competitive bidding are to obtain the best value for taxpayer dollars, to eliminate fraud and corruption, and to provide equal opportunity for contractors qualified to make bids. General requirements are spelled out in the Public Contracts Code of California. Specifically, a public notice of the project must be published in a newspaper of general circulation to give everybody a crack at the bidding on the project. The agencies must furnish complete plans and specifications and make them available to bidders. It's only fair that the bidders be fully informed of what they're called upon to bid on. Before awarding the contract, the state agency has to verify that the contractor making the bid is indeed licensed by the Contractor State License Board in the proper classification. Over on page 28, at the top of the page here, it explains how to go about submitting a bid on a public contract job. Under contractor eligibility, before bidding on a public works project, a public works contractor must meet certain requirements, criteria. They run the length of page 28 and on to page 29, and you want to highlight some of these requirements. The first one is to register as a public works contractor with the Department of Industrial Relations. To register, the contractor has to be properly licensed, has to carry workers' compensation for all his employees. Next requirement is to pay prevailing wage. You want to highlight that all workers employed on public works projects have to be paid the prevailing wage determined by the Director of Industrial Relations. Usually the prevailing wage is the wage arrived at by bargaining with labor unions, Operating Engineers Union, the Carpenters Union, International Brotherhood of Electrical Workers, whatever union is appropriate to the trade. The union wages will probably be regarded as the prevailing wage rates for public works projects. The next requirement is to follow apprenticeship requirements on projects of $30,000 or more. The next requirement is to maintain and submit certified payroll records. You want to highlight these words. Contractors and subcontractors on most public works projects are required to submit certified payroll records monthly to the Labor Commissioner using Department of Industrial Relations electronic certified payroll reporting system. So, like it or not, you're being ushered into the high-tech age to make your payroll reports to the Labor Commissioner. Over on page 29, the last requirement here to establish eligibility to bid on a public works job is to maintain liability insurance. Again, you want to highlight these words. Public works contractors must also carry liability insurance. A $1 million policy is generally considered the minimum. The public agency must be named as the insured or named as an additional insured along with the contractor. If the contractor fails to register with the Department of Industrial Relations, he's simply ineligible to bid on a public works job. Advertisements for bids. As noted earlier, the public agencies advertise their projects in newspapers of general circulation in the county where the project is to be located. Awarding the bid. The bid must be, as it says in the law, responsive, and the contracts are to be awarded to the lowest responsible bidder. Responsive bid means that all the forms required by the public agency are filled out correctly and signed. All required documents are turned in on time, and all the material terms of the contract are included in the bid, specifically the price, the date of anticipated completion of the project, and, of course, quality of the construction materials and workmanship. Those are all to be included in a responsive bid. Lowest responsible bidder means that the public agency does not necessarily have to accept absolutely the lowest bid. It's the lowest responsible bid that gets accepted. Whether or not the bid is responsible is a matter of interpretation. Depends on a lot of things. The experience of the bidder, the solvency of the bidder, whether or not the bidder has the proper credentials. A lot of things go into consideration of who's responsible bidder and who isn't. But that word responsible is very important to the interest of the taxpayers. We don't want public agencies spending taxpayer money on contractors who don't really have the knowledge, ability, or the resources to do the project correctly. At the top of page 30, we have a comment here about another protection for the taxpayer dollars, and that is in the form of a retention. A retention is the public agencies withholding a certain percentage of the contract price. It can be as much as 5%, against the possibility that the construction done by the contractor will turn out to be defective somehow. If that's the case, then the public agency still has 5% of the contract price withheld to be applied toward repairs or whatever needs to be done to rectify the defective situation. Construction delays in public works projects. There are 4 kinds of delays identified here. The first is an excusable delay. You want to highlight this. An excusable delay is a delay due to conditions that are unforeseeable and outside the contractor's control. Typical example, extreme weather conditions causing unavoidable delays in the progress of the project. In this case, the contractor can usually get an extension of time to finish his project, but usually he doesn't get extra compensation. He just gets an extension of time. The second category of delay is inexcusable delays. Inexcusable delays. Those are delays caused by the contractor himself, typically failing to order supplies on time, failing to properly schedule his subcontractors, inadequate staffing. In these cases of inexcusable delays, the contractor is often required by the contract to pay liquidated damages. That is to say, amounts of money, usually per day, agreed upon in the contract in the event that the contractor does cause a delay inexcusably. It could be $100 a day, it could be $1,000 a day, depending on the scope of the project. Third category of delays on a public project is compensable delays, delays caused by the agency, failing to make progress payments, too many change orders, failing to make inspections. These delays, since they're caused by the agency, should not prevent the contractor from being compensated for his work. And finally, we have concurrent delays, delays caused by both the contractor and the agencies. These are usually problematical because it has to be determined if one party is more at fault than the other. And of course, that gives rise to lengthy and expensive arguments. And that's about all we have to say about public works contracts. Now, turning over to page 32, Subletting and Subcontracting Fair Practices Act. As it says here very clearly, the purpose of California's Subletting and Subcontracting Fair Practices Act is to discourage bid shopping, sometimes called bid peddling, on public projects. Bid shopping occurs when the general contractor reveals the amount of the lowest bid received to date by a subcontractor in order to pressure other subcontractors to submit even lower bids. In the private sector, this may be regarded as immoral. In the public sector, it's illegal by virtue of the Subletting and Subcontracting Fair Practices Act. Any person making a public contracts bid has to list the name and business address of each subcontractor performing work greater than 0.5% of the prime contractor's total bid. And the portion of the work to be done by each subcontractor has to be spelled out and there can only be one subcontractor for each portion of the work. Farther down the page on page 32, you want to highlight the statement, if a prime contractor fails to specify a subcontractor for some specialized portion of the work, why then the prime, in effect, agrees that he or she is fully qualified to perform that work, that specialized work, whether it's plumbing or electrical or roofing or whatever. And at the bottom of the page, again, you should highlight these words, agencies consider subcontractors to be employees of the contractor in the sense that the contractor is held responsible for the work performed by his subcontractors. Turning to page 33, if the prime contractor's bid is accepted and a sub was designated in the bid, the prime may not substitute a subcontractor, a new subcontractor, unless the awarding authority agrees to do so, and the awarding authority must base its agreement to do so on one or more of the following reasons. You've got 9 reasons listed there for why the awarding authority may agree to a substitution of a subcontractor. You want to highlight these words halfway down page 33. Before approving a substitution of a subcontractor, the awarding authority must notify the sub by certified or registered mail of the prime contractor's request to make the substitution. The subcontractor has 5 working days to submit a written objection. If the sub does file an objection, the awarding authority will conduct a hearing. You should also continue with the highlighting. If the prime contractor commits an accidental clerical error in listing a sub, the prime must give written notice to the awarding authority and all subs involved within 2 working days after the prime bid opening by the awarding authority. The sub listed in the error has 6 working days in which to file an objection to the substitution, and if the sub does object, then a public hearing has to be conducted to see whether or not the substitution is warranted. At the bottom of page 33, under the heading Bond Requirements under the Subletting and Subcontracting Fair Practices Act, we note that on public works projects, the prime contractor is often required to obtain performance and payment bonds. What are those? Well, a performance bond, sometimes referred to as a completion bond, is a guarantee from a surety company that the individual posting the bond, in this case subcontractor, will complete all the work specified in the subcontract. If the subcontractor fails to complete the work specified, then the bonding company will step into the subcontractor's shoes and make sure that another subcontractor is hired to finish the work of the original the first subcontractor. A payment bond is often referred to as a labor and materials bond, and it guarantees the payment of all bills incurred by the individual posting the bond, the subcontractor, for all the labor and materials that need to be paid for. So again, if the subcontractor fails to pay his laborers or his materials suppliers, the bonding company will step into the sub's shoes and directly pay off the workers and the suppliers, and then turn to the sub for reimbursement. There's a brief look at performance and payment bonds. These bonds are also covered in more detail in Chapter 6, along with other types of surety bonds. Now lastly, I want to call to your attention the glossary on pages 36, 37, and 38. Actually, every chapter has a glossary at the end of terms used in the construction industry. You should pay close attention to the glossary at the end of every chapter. And that, I think, completes our tour of Chapter 2 on contracts. And in closing, let me simply say I wish you all the best of luck in your construction careers.